Emergence of modern concept of administrative law. The ruling political gospel of the 19th century was laissez-faire, in which the state was characterized as the law and order state. This philosophy envisaged minimum governmental control. It was an era of maximum free enterprise and contractual freedom and minimum governmental responsibility in functions. The management of social and economic life was not regarded as the governmental responsibility. In this system, the role of the state was conceived to be negative, as its interest extended primarily to a few activities only, like defending the country, maintaining law and order, resolving disputes, and collecting a few taxes to finance these activities. But the laissez-faire doctrine resulted in human misery. It came to be realized that the bargaining position of every person in the society was not equal, and uncontrolled contractual freedom led to exploitation of the weaker by the stronger and concentration of wealth in a few hands. It came to be realized that the state should assume a positive role by taking active interest in ameliorating the conditions of the poor. This approach led to the demise of laissez-faire and emergence of the concept of the social welfare state, which lays emphasis on the role of the state as a vehicle of socio-economic regeneration and welfare of the people. The emergence of the modern welfare state has affected all the democracies very profoundly, leading to state activism. The 20th century has witnessed a phenomenal increase in the area of state operations touching every aspect of human life. The state has taken over a number of functions which were previously left to private enterprise. A large number of government enterprises have thus come into being. The 20th century has seen a decline in the importance of the institution of contract. Many relations are no longer governed by contract. Government largely allocates resources in the economy and effectively manipulates. Nature, meaning, scope and development of administrative lane. 13. The market by price contracts, wage controls and other legal and fiscal arrangements. This state activism has led to one inevitable result. In its quest to improve physical, moral and economic welfare of the people, the state has assumed more and more powers to regulate society. Increasing state activities has resulted in tremendous increase of work for all organs of the state. But due to various reasons, the largest extension in depth and range of functions and powers has taken place at the level of the executive-cum-administrative organs. Multiple kinds of administrative organs, bodies start discharging multifarious functions which are traditionally presumed to be the domain of legislature and judiciary. It makes policies, provides leadership to the legislature, executes and administers the law, and takes manifold decisions. With the emerging pattern of global governance as a consequence of globalized interdependence, the administrative authorities are exercising not only the traditional functions of administration, i.e., putting the law into effect, but also exercising their power in relations to rulemaking, quasi-legislative function, decision-making, quasi-judicial function, application of rules and ministerial action. Thus, it legislates and adjudicates as well. It exercises legislative power and issues a plethora of rule, bylaws, and orders of a general nature in the form of delegated legislations. Today, not all disputes are decided by the courts in the ordinary manner. The administration has acquired powers of adjudication, and thus have emerged a plethora of tribunals, apart from other innumerable adjudicative bodies, diversified in structure, jurisdiction, procedures, and powers. Administration has assumed such an extensive, sprawling, and varied character that it is the all-pervading feature of life today. There is not a moment of a person's existence when he is not in contact with the administration in one way or the other. This vast proliferation of administrative functions through numerous administrative organs, bodies, authorities results into the birth of administrative law, which has been characterized as the most outstanding legal development of the 20th century. Administrative law has grown and developed tremendously, in quantity, quality in the 20th century. It has become more articulate and definitive as a system in democratic countries. It has assumed a more recognizable form in the 20th century, so much so that it has come to be identified as a branch of public law by itself, distinct and separate from constitutional law. Reasons for rapid growth of administrative law. Administrative law is a byproduct of intense, positive form of modern functional government. The following factors are responsible for rapid growth and development of administrative process and consequently of administrative law. Administrative law. 1. Radical change in the concept, role of the state. The 19th century doctrine of laissez-faire no longer remains the governing principle of modern state, and it has given place to the doctrine of welfare state. The police state, with limited functions, has become a welfare state, with a plethora of duties and responsibilities, and this has led to the proliferation of administrative functions and powers. The state has not confined its scope to the traditional and minimum functions of defense and administration of justice, but has adopted a positive policy and as a welfare state has undertaken to perform varied functions. This resulted in the vast expansion of administrative process and consequently of administrative laws. 2. Inadequacy of traditional legislative organs. To perform a variety of functions and to exercise wide powers, a lot of legislation is required. But because of limitation of time, the technical nature of legislation, the need for flexibility, experimentation and quick action, the legislature cannot pass that quality and quantity of laws which are required for the functioning of a modern government. Consequently, it has to confer on the executive or other administrative agency the authority to make subordinate legislations. Inevitability of delegation of legislative power resulted in fast development of administrative legislative process and consequently of administrative law. 3. Inadequacy of orthodox system of adjudication. There has been tremendous increase in the litigations against the state on account of its extensive interference with public life and activities. Many a time the nature of dispute is technical and requires speedy disposal. But the traditional system of adjudication through courts proved to be inadequate as it is expensive, dilatory, and suffers from procedural complexities. It is unworkable where the subject matter is dynamic and technical. Consequently, adjudicatory powers have also been conferred on the administrative authorities. Quasi-judicial functions are regarded as one of the important functions of the administrative bodies. There has been tremendous growth in quasi-judicial bodies. Many tribunals established for exercising adjudicatory powers. They are not bound to follow the rules of evidence and procedure. They provide quick, cheap and simple remedies. Tribunalization of adjudication resulted in fast development of administrative adjudication process and consequently of administrative law. 4. Heavy industrialization and urbanization. Heavy industrialization has created complex problems such as haphazard urbanization, ruthless exploitation of natural resources, pollution, unemployment, industrial conflict, social conflict, corruption etc. These problems cannot be solved except with the intervention of the state. All this has led to the growth of administrative process and consequently of administrative law. Nature, meaning, scope and development of administrative law. 1.5. 5. Quick adoption and enforcement of preventive measures. Administrative authorities could take immediate preventive measures like licensing, rate fixing, rationing etc. As opposed to regular courts, which has to wait for parties to appear before issuing any kind of directions. Administrative authorities could take effective steps for enforcement of preventive measures like suspension, revocation and cancellation of licenses, destruction of contaminated articles etc., which were generally not available through regular courts of law. Moreover, preventive measures are more desirable than punishing a person after committing an offense. This has led to the expansion of the administrative power and process and of administrative law. 6. Demand for protection of rights. Now the people expect from the government that it will not only define their rights but also protect them. The government is expected to take effective steps to enable the people to enjoy their rights in reality. This has also led to the development of administrative law. Conclusion. There are many other factors responsible for the rapid growth of administrative law. No list of causes, however lengthy it may be, can be complete and exhaustive. But a modern functional government wedded to the philosophy of social welfare state, endowed with the obligation to secure to its citizens from their cradle to their grave, is the main reason behind the growth of administrative process law. The vast powers of administration, if exercised properly, may lead to the emergence of a welfare state. But, if abused, they may lead to administrative despotism and a totalitarian state. The development of administrative law has been widely received because it provides an instrument of control of the exercise of vast administrative powers. Need, object, purpose, utility, importance of studying administrative law. Due to the emergence and establishment of the welfare state, there has been tremendous increase in the activities, functions, responsibilities, obligations of the state. This shift in the political economy has made it inevitable to create a mammoth administrative machinery. These administrative authorities have been conferred a lot of discretionary powers which are not only of administrative nature but also of quasi-legislative and quasi-judicial nature. Thus, the modern-day administration became the repository of huge authority and all kinds of powers. With the increase in the functions and powers of the administration, it was felt that there should be an adequate check and effective control on the workings of the administration so as to prevent abuse of powers which will be detrimental to the welfare of the people. Therefore, the administrative law was evolved by the judiciary in 1.6. Administrative law. Order to ensure that the powerful administrative machinery does not become an unruly horse. It has now been fully realized that uncontrolled or unregulated administrative power may result in the establishment of new despotism. The object of administrative law is to find out the new devices and strengthening the existing devices for the control of the administrative powers, actions. The principal purposes of administrative law are as under. 1. To keep administrative authorities within their limits. Power corrupts and absolute power corrupts absolutely, is of profound importance in the study of administrative law. According to Lord Denning, the main object of the study of administrative law is to unravel the way in which administrative authorities could be kept within their limits so that the discretionary power does not convert into arbitrary power. Administrative law has been developed to regulate the exercise of discretionary powers and to provide safeguards against arbitrary and illegal actions of the administration. It is the demand of prudence that when sweeping powers are conferred on administrative organs, effective control mechanism be also evolved so as to ensure that the bureaucracy do not use their powers in an undue manner or for an unwarranted purpose. It is the object of administrative law to ensure that the governmental functions are exercised according to law, on proper legal principles and according to rules of reason and justice. That adequate control mechanism, judicial and others, exists to check administrative abuses without unduly hampering the administration in the discharge of its functions efficiently. 2. To reconcile individual right, interest, liberty with public right, interest, powers. The focal point of study of administrative law is the reconciliation of power with liberty. In every democratic country, the protection of civil rights and liberties and inevitable growth of the powers of the administration under the garb of social welfare state have to be reconciled. According to Wade and Forsyth, the primary purpose of administrative law is to keep the powers of government within their legal bounds so as to protect the citizens against their abuse, at the same time to enable it to perform its obligations. Administrative law is concerned with the evolution of the principles to maintain ideal balance between administrative power and individual liberty. Administrative law protects the individuals from the arbitrary and unlawful act of the administrative authorities. It provides means to control the administrative action so that the administrative authorities may not unlawfully interfere with the rights of the individuals. In spite of such control, if the administrative authorities interfere with the rights of the individual, the aggrieved person is provided with adequate remedies against the unlawful. Point 7. Actions of the administrative authorities. Government is also held liable for the torts committed by its servants. A democracy will be no better than mere facade if the rights of the people are infringed with impunity without affording them proper redressal mechanism. 3. To check corruption. Broad and uncontrolled discretionary powers have inherent seeds of misuse or abuse of powers and corruption. In the absence of guiding norms, principles to regulate the exercise of such powers and an effective supervisory mechanism, there may be no way to assess whether a particular decision arrived at by an administrator is bona fide or is motivated by some corrupt considerations. It will be extremely difficult, if not impossible, to check corruption in a country where uncontrolled powers are conferred on administrators. It leads to negation of the rights of the people, rule of law and democracy. A proper system of administrative law helps in averting this danger to a great extent. Administrative law attempts to devise all the possible modes of control for providing adequate safeguards against the misuse, abuse of their powers. For example, in India, Ombudsman, Lokayukt and Central Vigilance Commission, CVC, etc. are comparatively new methods to check corruption, i.e., to keep control on the powers of the administrative authorities. Conclusion. Apart from these, there are various other objects, needs, purposes of studying administrative law. The study of the administrative law is not an end in itself but a means to an end. According to Schwartz, the goal of administrative law is to ensure that, so far as possible, the individual and the state are placed on a plane of equality before the bar of justice. This goal is achieved by administrative law by providing cogent answers to the following problems. A. What power does the administration exercise? B. What are the limits of such powers? D. How the rules, regulations and bylaws are made by administrative agencies. A. How subordinate law-making is controlled. F. What are the ways in which the administration is kept within limits? G. What remedies are available to the individual against the illegal actions of the administration? Prof. Wade also emphasized the same idea by saying that the central question in administrative law is, how can the legal ideas of fair procedure and just decision be infused into the administrative powers of the state? C. What procedures does it follow in the exercise of these powers? Numerous norms and rules have been developed by the judiciary known as principles of administrative law, by which it is ensured that 1. The government's power are exercised according to law, on proper legal principles, according to the rules of reason and justice and not on the mere caprice or whims of the administrative bodies. 2. The administrative powers are exercised in reconciliation with the law, dictates of individual liberty. 3. The individual has adequate remedies when his rights are infringed by the administration. 4. The individual is protected from the corruption of the administration. 5. There is impartial determination of disputes between the individual and public bodies. 6. Those who exercises public power are accountable to the people. The administrative bodies are required to adhere to these norms and rules while discharging their obligations. On the whole, the primary object of administrative law is to give effect, i.e., to protect, foster and maintain the rule of law in administrative process. The administrative law consistently aims at strengthening the existing methods of control and finding out new methods of controlling quasi-legislative, quasi-judicial and other functions and powers of the administrative authorities. Meaning and definition of administrative law. In almost every country, irrespective of its political philosophy, the administrative process has increased so tremendously that it is impossible to attempt a scientific, precise and satisfactory definition of administrative law which can cover the entire range of administrative process. It can be described but cannot be defined as it is not a statutory law but a judge-made law comprises of various principles which have been developed through numerous case laws. Many jurists have endeavored from time to time to define it, but none of the definition has completely demarcated the exact nature, scope, and content of administrative law. Either they are too broad or too narrow, either they include much more than what properly should be included within the scope of the subject, or else they leave out some essential aspect of administrative law. English approach to administrative law. Early English writers did not differentiate between administrative law and constitutional law, and, therefore, the definition they attempted was too broad and general. Dicey did not recognize the independent existence of administrative law. According to Dicey's formulation, administrative law relates to that portion of a nation's legal system which determines the legal status and liabilities of all state officials, which defines the rights and liabilities of private individuals in their dealings with officials and specifies the procedure by which those rights and liabilities are enforced. Dicey was obsessed with the French droit administratif, and so his formulations was mainly concentrated on judicial remedies against state officials, and he excluded other aspects of administrative law. His definition is narrow and restricted as it talks about only one facet of administrative law, i.e., the control and regulation of public officials, leaving out other considerations. For example, his definition does not. Point 9. Include officers of public corporation. Further, his definition does not mention anything about the working of administrative agencies, their powers, functions, or their control by Parliament, etc. According to Jennings, administrative law is the law relating to the administration. It determines the organization, powers, and duties of administrative authorities. This formulation of Jennings is too broad and general as it does not distinguish administrative law from constitutional law. He lays entire emphasis on the organization, powers, and duties to the exclusion of the manner of their exercise. Administrative law is not much concerned with the organization but is mainly concerned as to how the authority discharges its functions in relation to affected persons. His formulation leaves many aspects of administrative law untouched, especially the control mechanism. Prof. Griffith and Street criticized this formulation as 1. It excludes the manner of the exercise of powers and duties by the administrative authorities, i.e., the procedure adopted, followed by them in exercising their powers. And 2. It does not include the remedies available to an aggrieved person when his rights are adversely affected by the administration. American approach to administrative law. The American approach is significantly different from the early English approach, in that it recognized administrative law as an independent branch of the legal discipline. The English administrative law does not lay much emphasis on procedures of administrative bodies, agencies, as does the American administrative law, where this branch of law is often designated as administrative process. The American approach to administrative law is depicted in the formulation of the leading scholar Davis. According to him, administrative law is the law concerning the powers and procedures of administrative agencies, including especially the law governing judicial review of administrative actions. An administrative agency, according to him, is a governmental authority other than a court and other than a legislative body, which affects the right of private parties even through rule-making or adjudication. Davis further holds, apart from judicial review, the manner in which public officers handle business unrelated to rule-making or adjudication is not a part of administrative law. This means that much of what political scientists call public administration is excluded. Emphasis of administrative law is on procedures for rule-making and for formal adjudication. But Davis excludes application of the rule, which according to him belongs to the domain of public administration. Even this classification cannot be considered complete, as he excludes the control mechanism, the control exercised by the legislature, the higher administrative authorities, and the mass media representing public opinion, along with the vast area of administrative action which is neither quasi-legislative nor quasi-judicial. Secondly, his formulation does not include the consideration of purely discretionary functions, falling within the category of administrative function. In modern times, discretionary administrative functions have vast scope and range, and the control mechanism of these functions constitutes an important subject for the study in administrative law. According to Prof. Schwartz, administrative law is that branch of the law which controls the administrative operations of the government. It sets forth the powers which may be exercised by administrative agencies, lays down the principles governing the exercise of those powers, and provide legal remedies to those aggrieved by administrative action. The definition of Schwartz clarifies that administrative law is not regarded as the law relating to public administration, the way commercial law is the law relating to commerce or land law is the law relating to the land, but it is the law relating to administrative agencies. His formulation emphasized that administrative law is limited to the powers vested in administrative agencies, b. the requirements imposed by law upon the exercise of those powers, and c. remedies available to those aggrieved by administrative action. According to Schwartz, administrative law relates more to procedure and remedies than to substantive law. The substantive law made by the various agencies is not dealt with, except as it may be used to illustrate aspects of the procedural and remedial law. His formulation of administrative law is limited to powers and remedies and answers the following questions. 1. What powers may be vested in administrative agencies? 2. What are the limits of the powers? 3. What are the ways in which agencies are kept within those limits? Distinction between English and American approach. After analyzing both the approaches, it may be noticed that while the American view emphasizes on procedure used by administrative agencies in exercising their powers, the English view does not mention procedure directly and specifically and is left to be implied from such broad words as organization, powers, and duties. Thus, English approach is substantive in nature, whereas American approach is procedural in nature. Schwartz explains that the focus in America today is on the administrative process itself, upon the procedures which administrative agencies must follow in exercising their powers. Indian approach to administrative law. After critically evaluating the different approaches on the formulation of administrative law, the Indian writers approach this issue in a more balanced way, which can be termed as the right blending of the English and American views. The definition given by Prof. M.P. Jan is quite comprehensive. He defines, administrative law deals with the structure, powers and functions of the organs of administration, the limits of their powers, the methods and procedures followed by them in exercising their powers and functions, the methods by which their powers are controlled, including the legal remedies available to a person against them when his rights are infringed by their operation. Administrative law, according to this definition, deals with 4 aspects. Firstly, it deals with composition and the powers of administrative authorities. The expression, organs of administration, includes all kinds of public or administrative authorities. Secondly, it fixes the limits of the powers of those authorities. Thirdly, it prescribes the procedure to be followed by these authorities in exercising such as. The procedure must be fair. Administrative law must ensure powers. That powers are exercised according to law, on proper legal principles, according to the rules of reason and justice, and not on the mere caprice or whim of the administrative officers. Fourthly, it controls these administrative authorities through judicial and other means. Control of the administration refers to control through judicial and other means, i.e., extrajudicial means, e.g., tribunals, ombudsman, etc. The administrative law must ensure that the individual, being in the weakest defensive position against the mighty power of administration, had adequate remedies when his rights were impinged by the administration. C.K. Tikwani defined administrative law as follows. Administrative law is that integral branch of the Constitution which deals with powers and duties of administrative authorities, the procedure followed by them in exercising the powers and discharging the duties, and the remedies available to aggrieved person when his rights are affected by any action of such authorities. Prof. I.P. Massey defined administrative law as follows. Administrative law is that branch of public law which deals with the organization and powers of administrative and quasi-administrative agencies and prescribe principles and rules by which an official action is reached and reviewed in relation to individual liberty and freedom. This definition makes clear the nature and scope of administrative law. Conclusion: after considering all these definitions, it can be concluded that administrative law is the law which deals with the powers and functions of the administrative authorities, with the limits of their powers, with the procedures to be followed by them in the exercise of their powers and functions, with the method of control of their powers, and with the remedies available to the persons in case of violation of their rights by them. The administrative law aims at the establishment and maintenance of rule of law in the country. Nature: uncodified judge-made public law. Administrative law has been emerged as one of the most significant branch of public law in contradistinction with a private law which deals with the relationship of individuals inter se. Administrative law primarily defines and regulates the relationship between the individual and the state. It is concerned with the composition, powers, duties, rights and liabilities of the various organs of the government which are engaged in public administration. Early English writers held the view that it is logically impossible to distinguish administrative law from constitutional law because both are concerned with functions of the government and are part of public law. However, Holland held that constitutional law describes the various organs of the government at rest, i.e., static aspects of the government, while administrative law describes them in motion, i.e., dynamic aspects of the government. According to him, constitutional law is concerned with structure while administrative law is concerned with functions. Administrative law is law in real sense, but it is not a codified, written or precisely defined law like property laws, land laws, labor laws, etc. It is unwritten, uncodified, and is generally called judge-made law because it has been developed over time by courts according to requirements of numerous cases. Prof. Wade says the essence of administrative law lies in judge-made doctrines which apply right across the board and which therefore set legal standards of conduct for public authorities generally. Contemporary administrative law includes statute law, administrative rulemaking, precedents, customs, administrative directions, etc. Administrative law includes the study of the existing principles and also of the developments of certain new principles according to the need of the time which administrative bodies, agencies must follow while discharging their powers. Thus, administrative law is dynamic in nature as it is constantly evolving. It is being increasingly developed to prevent the administration from degenerating into arbitrariness and abuse its powers. It attempts to devise principles by which the executive and its various instrumentalities and agencies are kept within the limits of their powers. Thus, the administrative law acts as means to achieve the ends or goals specified in the Constitution. Sweep, extent, ambit, scope, content of administrative law. Since administrative law is a constantly evolving law, it is difficult to define it and it is equally difficult to ascertain precisely its scope, ambit of operation. The central theme of administrative law is to reconcile liberty with power and to protect the rights of the people against the administrative excesses. But to implement this central theme, administrative law embraces a wide variety of functions and becomes an all-pervasive legal discipline. Administrative law. Is concerned with administration, and sometimes the expression administration is explained in negative way by saying that what does not fall within the purview of the legislature and judiciary is administration. Therefore, the ambit, scope of administrative law is almost uncertain and constantly expanding. It is often said that none can specialize in administrative law. Apart from pure administrative and executive functions, The administrative bodies exercise legislative functions by way of delegated legislation substantially affecting the rights of public at large. Administrative agencies also exercise powers of adjudication of disputes by establishing a number of administrative tribunals. Now, if proper controls and safeguards to check this wide discretionary powers of the executive are not provided, the public at large would be prejudicially affected. All this results into establishing a very wide ambit, scope of administrative law. According to Sir William Wade, administrative law is the law relating to the control of governmental power. He stated, the organization, the methods, the powers, whether styled administrative, legislative or judicial, and the control by judicial authority of all public authorities is the ambit of administrative law in UK. He further says, as a second approximation to a definition, administrative law may be said to be the body of general principles which govern the exercise of powers and duties by public authorities. This is only one facet of the mass of law to which public authorities are subject. All the detailed law about their composition and structure, though in a sense related to administrative law, lies beyond the scope of the subject. According to Prof. K.C. Davis, administrative law is limited to law concerning powers, procedure of administrative agencies, including the law governing judicial review of administrative action. It does not include the enormous mass of substantive law produced by agencies, most of which is beyond the understanding of lawyers as such. Administrative law is restricted to some activities of agencies having ways of adjudication or rule making. It includes judicial review of powers, executive or administrative action not involving either adjudication or rule making. While dealing with the nature and scope of administrative law, Friedman says that administrative law includes the law relating to 1. The legislative powers of the administration, both under common law and under statutes. 2. The administrative powers of the administration, both under common law and under a vast sway of statutes. 3. The judicial and quasi-judicial powers of administration, all of them statutory. Four, the legal liability of public authorities. And 5. The power of the ordinary courts to supervise the administrative authorities. According to Prof. Griffith and Street, the operation and control of administrative authorities being the chief purpose of administrative law, it deals with the following inquiries. 1. What sort of powers does the administration exercise? 2. What are the limits of those powers? 3. What are the ways in which the administration is kept within those limits? 4. What are the procedures followed by administrative authorities? 5. What are the remedies available to a person affected by administration? According to Garner, the subject of administrative law includes the study of 1. The institutions and administrative processes, 2. The principal sources of governmental legal powers, 3. The mechanism by which citizens' grievances in respect of governmental actions may be examined, and where appropriate redress be afforded, 4. The public corporations, and 5. The administration of local government and the general legal principles applying to local authorities. A careful analysis of the various definitions of administrative law, and after observing views of the various writers regarding its scope, ambit, it may be concluded that the administrative law deals with the following aspects of administration. 1. Structures, powers, functions of the administrative authorities. It deals with the organization, composition of administrative and quasi-administrative bodies, agencies such as corporations, boards, universities etc. Nowadays, these bodies exercise numerous powers and thus charge multifarious activities, functions. The residue of the governmental powers and functions, i.e., the governmental powers and function which are not vested in the legislature and judiciary, are exercised or performed by the administrative or executive authority. The nature of the powers exercisable by the administrative authorities can be studied under the following heads: purely administrative actions and powers. B. Quasi-legislative, i.e., rule-making powers of administrative bodies in the form of delegated legislations. And C. Quasi-judicial, i.e., adjudicative functions and powers of administrative bodies. Besides actions incidental to these, such as investigatory, supervisory, declaratory, or prosecutory, form part of administrative law. 2. Limitations on the powers of administrative authorities. The administrative authorities are supposed to act within the limits of Point 15. Their powers given to them by the acts and statutes. Where they are armed with discretionary powers, decisions are to be made by them in the public interest. In the case of discretionary powers, the administrative authorities enjoy the opportunity to make a choice out of available alternatives. The key function of administrative law is to find out the ways in which the administration could be kept within limits so that discretionary power may not become arbitrary and unfair. 3. Procedural safeguards, guarantees. Administrative power must, as far as possible, be regulated so that it may not be abused. It includes the study of the existing principles and also the development of new principles for regulating the functioning of administrative bodies. The administrative law deals with the procedures which are to be followed by the administrative authorities while discharging their powers and functions. This is to ensure fairness of the procedures adopted by the administrative authorities. The concept of natural justice, fairness, and reasonableness occupies an important place in the study of administrative law. 4. Methods by which powers are controlled. Apart from procedural control, administrative law also deals with various control mechanisms through which the administrative agencies are kept within bounds and made effective in their dealings with individuals. This review process includes parliamentary as well as judicial control of administrative actions. It also includes review by higher administrative authorities. Public opinion and mass media are important controls on any administration which cannot be ignored. In the US, opinion polls and mass media exercise much more effective control on the administration than any other single controlled mechanism and has the potentiality of preempting any adverse administrative decisions. Administrative law also deals with the new devices of the control of administrative action like the establishment of Lokayukt, the Central Vigilance Commission, CVC, which have been established to check the corruption in the administration. These are safeguards against abuse of administrative powers. 5. Legal remedies available to an aggrieved person. Administrative law deals with the legal remedies available to an aggrieved person whose right has been infringed by illegal, arbitrary actions of the administrative authorities. Various constitutional remedies such as writs and ordinary, equitable remedies such as injunctions, damages, declaration are easily available. Easy access to justice proves to be an effective check on bureaucratic adventurism in the exercise of public power. Law. 6. Liability of the government in tort or contract. Governments have been responsible for tortious and contractual liabilities for the wrongs committed by their servants and agents. Article 300 makes provisions in respect of tortious liability of the government for the acts of its servants. Recent decisions have enlarged the areas of governmental liability in tort. 7. Public undertakings, corporations and government companies. Wide powers conferred on these instrumentalities of the state are subject to inherent limitations that they should be exercised honestly and in good faith. In the expanding horizon of modern jurisprudence, lifting of corporate veil is permissible. The court can look behind the veil to see the real face of the corporation. Conclusion. It is very difficult to specify the exact ambit of the administrative law because the area of administration is expanding day by day. But in general, it can be concluded that administrative law helps in identifying the following issues. 1. Who are administrative authorities? 2. What is the nature of powers or functions exercised by these authorities? 3. What are the limitations, if any, imposed on these powers? 4. What is the procedure followed by the administrative authorities? And 5. What remedies are available to an individual adversely affected by illegal act of administration. In ultimate analysis, administrative law comprehensively deals with the ways and means to keep the multifarious powers of administrative authorities under control and to prevent the autocratic rule by administrative authorities. The modern welfare state takes care of its citizens from cradle to grave. As a result of which the governmental functions have multiplied by leaps and bounds which have widened the scope and ambit of administrative law. Recent growth in global administrative space and the emerging intergovernmental regulations by global agencies with tremendous rational consequences has further added new focus to administrative law with global dimensions necessary to make new world economic order inclusive and equitable. This has added to the scope of administrative law as an outsourced policy delivery mechanism to enforce responsibility and accountability in global governance not only on states but also on corporations, firms, autonomous agencies, individuals and civil society institutions. DA. Administrative LAWV. Constitutional law. Constitutional law as well as administrative law are parts of the public law and both are closely interrelated and overlap extensively. Various principles derived from the constitutional law form the basis of the administrative law and had a major impact on the growth of administrative law. That is why constitutional law is regarded as one. 17. Of the most important source of the administrative law. The knowledge of the constitutional law is must to comprehend the correct position of administrative law. According to Keith, it is logically impossible to distinguish administrative law from constitutional law and all attempts to do so are artificial. Constitutional law is genus and administrative law is a species of constitutional law. The rule of law is a basic concept which runs through both of them. To the English writers, there was virtually no difference between constitutional law and administrative law. Garner opines that the distinction between both of them is of convenience and custom than logic. Prof. Wade is of the view that the whole of administrative law, indeed, may be treated as a branch of constitutional law, since it flows directly from the constitutional principle of rule of law. Since the fundamental principles of administrative law are derived from different constitutional law principles such as rule of law, separation of power, sovereignty of the Constitution, independence of the judiciary, protection of the fundamental rights of the citizens, etc. It can be said that administrative law has its foundations in constitutional law. The hard fact is, however, that now administrative law has acquired the status of an independent legal discipline and many writers have recognized a certain degree of difference between them. Holland states that, constitutional law describes the various organs of government at rest, while administrative law describes them in motion. According to Hood Phillips, constitutional law is concerned with the organization and functions of government at rest, whilst administrative law is concerned with that organization and those functions in motion. According to Jennings, constitutional law deals with the general principles relating to the organization and powers of various organs of the state, whereas administrative law deals with the organization, functions, powers and duties of administrative authorities. According to Maitland, while constitutional law deals with structure and the broader rules which regulate the functions, the details of the functions are left to administrative law. Whatever may be the arguments and counter-arguments, there are certain differences between constitutional law and administrative law. These are: 1. Constitutional law deals with fundamentals while administrative law deals with the details. 2. The constitutional law, being the fundamental, the basic, supreme and highest law of the land, occupies a superior status. Administrative law is subordinate to the constitutional law. All laws, including the administrative law, if repugnant to the Constitution, is liable to be struck down by the courts as ultra vires. Three, the constitutional law has full control over administrators. Whereas in administrative law, administrators play independently under the law. 4. Constitutional law lays equal emphasis on all the principal organs of the state, while administrative law mainly concerns with the executive, administrative organs of the state. 5. Constitutional law deals with the general principles, fundamental relating to the organization and powers of all three organs of the state, while administrative law deals with the body of law which defines the powers of the executive and regulates their functioning. Administrative law deals with the detailed application of the various laws, rules, principles. 6. Constitutional law is both theory and practical, whereas administrative law is only practical and functional law. 7. Constitutional law deals with the rights of the individuals in general, including fundamental rights. Whereas the administrative law is mainly concerned with the remedies available to individuals in their dealings with the administrative authorities, when their rights have been infringed. Development of administrative law. The administrative law has been characterized as the most outstanding legal development of the 20th century. The administrative law has matured and grown tremendously in quantity and quality in the 20th century in various independent and democratic countries. However, it does not mean that there was no administrative law in any country before the 20th century. In France, the administrative law, or droit administratif, was fully developed even before the 20th century. However, in the 20th century, it has been given much more importance because of the emergence of the concept of modern welfare state, as a result of which the administrative authority grew and made its presence strong in all domains of social and economic life such as industry, commerce, education, transport, banking, insurance, etc. A. Administrative law in UK. In Britain, administrative law starts taking shape after the Industrial Revolution, because this caused the government to provide numerous welfare measures to the working class who migrated in mass from rural to urban areas. As a result of various welfare enactments, various administrative agencies have been created for administration as well as adjudication. But, by and large, the existence of administrative law as a separate branch of law was not accepted until the advent of the 20th century. Dicey, the famous architect of the rule of law in 1885, denied the existence of administrative law in England by saying that, in England, we know nothing of administrative law and we wish to know nothing about it. But his contemporary Maitland was quite conscious of the true position, as he observed in 1887, "If you take up a modern volume of the reports of the Queen's Bench divisions, you will find that about half of the cases reported have to do with rules of administrative law." However, after the famous decisions of the House of Lords in Board of Education vs. Rice, 1911, and of Local Government Board vs. Arledge, 1915, Dicey himself became conscious of the emergence of administrative law in England. In his article, The Development of Administrative Law in England, he observed, legislation had conferred a considerable amount of quasi-judicial authority on the administration, which was a considerable step towards the introduction of administrative law in England. In the last edition of his book, Law and the Constitution, published in 1915, Dicey admitted that due to increase of duties and authority of the officials during the last 30 years, some elements of droit administratif had entered in the law of England. Dicey's denial of administrative law in England is attributed to his misunderstanding. He thought that administrative law was incompatible with the rule of law, with the common law and with the English constitutional liberty. While elaborating the rule of law, he excluded altogether administrative law and special system of administrative courts. Dicey misconception threw chilly shadow on administrative law. Accordingly, Griffith and Street have observed that the study of administrative law had to suffer a lot because of Dicey's conservative approach. Of course, in due course of time, scholars made conscious efforts to know the real position. But even to them, the study of administrative law was limited only to two aspects, viz. delegated legislation and administrative adjudication. In the beginning of the 20th century, Dicey's denial of the administrative law was won over and the importance of administrative law was recognized. The first book published on administrative law in England was authored by Dr. Port in 1929. In the same year, Lord Chief Justice Hewitt bitterly criticized the expansion and unregulated growth of administrative powers in his book, New Despotism. He stated that bureaucracy had become the true rulers of England, and if it is not properly controlled, it may result in new despotism. His views was given much importance, and a committee on ministers' power, Donoughmore Committee, was appointed in 1929 to examine the problems of delegated legislation and the judicial and quasi-judicial powers exercised by the officers appointed by the ministers, and to suggest effective steps and suitable safeguards to ensure supremacy of the rule of law. The committee submitted its report in 1932 and made certain recommendations with regard to better publication and control of subordinate legislation. As a result, a select committee on statutory instruments was established. B. Statutory instruments was established in the House of Commons. The Statutory Instruments Act, 1946 was passed, which purported to provide a comprehensive procedural code for the making of subordinate legislation. It enacts rules for publication of statutory instruments and also regulates laying procedure before Parliament. Further, the Crown Proceedings Act, 1947 was enacted. This act liberalized the law relating to civil proceedings against the Crown. It made the government liable to pay damages in cases of tortious and contractual liability of the Crown. It was, in a way, the abandonment of the famous doctrine, the king can do no wrong, which considerably expanded the scope of administrative law in England. In 1955, Frank's committee was appointed for considering and recommending the constitution and working of tribunals and inquires. As a result of its report, the Tribunals and Inquires Act, 1958 was passed. This act laid down certain general procedural principles to be applied to most administrative tribunals and inquires. It also provided for better control and supervisions of administrative authorities and tribunals by the courts of law. Since the Franks Committee report, the working of the tribunals improved. They were, now, to be seen as part of the machinery of adjudication. In 1961, an unofficial body known as Justice, UK section of the International Commission of Jurists, published a report as Citizen and the Administration, concerning grievances of citizens against misuse of administrative powers. The result was the establishment of the institution of Ombudsman, known as the Parliament Commissioner, under the Parliamentary Commissioner Act, 1967. Conclusion: because of all these developments, Lord Denning in 1971 in a case proclaimed that, it may truly now be said that we have a developed system of administrative law. In due course, the scholars reconciled themselves to the existence of administrative tribunals and administrative discretion. Lord Diplock went a step further and in 1982 in a case stated that recent development in England provided a system of administrative law which is in substance nearly as comprehensive in its scope as droit administratif in France. He observed that, progress towards a comprehensive system of administrative law that I regard as having been the greatest achievement of the English court in my judicial lifetime. According to the Smith's view, whether the law has attained a developed state is a matter of degree upon which reasonable persons may differ, but no reasonable person is now likely to define English administrative law out of existence, and its inclusion as a title in the current edition of Halsbury's Laws of England is not totally without significance as an indication of changing attitudes. Gradually, the administrative law occupies an important place in the British legal system. B. Administrative law in USA. Administrative law and administrative agencies in America are as old as American government themselves. In its very first session, the American Congress enacted 3 statutes conferring important administrative powers. According to Schwartz, the setting of the Interstate Commerce Commission, ICC, 1887, is considered to be the beginning of the American administrative law. The Commission was an autonomous body invested with broad powers of rule-making and adjudication to prevent excessive charges and discriminatory practices. The ICC served as a model for a host of other administrative agencies, endowed with the power to determine, by rule or by decisions, private rights and obligations. With the rapid growth in the activities of the ICC, the expression, administrative law, came into general use. In 1893, the very first book on administrative law titled, Comparative Administrative Law, was written by Frank Goodnow. He published in 1905 another book titled Principles of Administrative Law of the United States. In 1911, Ernst Freund brought out another book on administrative law titled Casebook on Administrative Law. The bench and bar, however, did not give any recognition to these works. The president of the American Bar Association, Elihu Root, however, foresaw the development of administrative law. In 1916, in his presidential speech, he said, "There is one field of legal development which has manifestly become inevitable. We are entering upon the creation of a body of administrative law, quite different in its machinery, its remedies and its necessary safeguards, from the old methods of regulation by specific statutes enforced by the courts." In the course of time, the ICC was invested with the powers to legislate, to prosecute and to decide cases. The American people found the activities of the Commission to be very beneficial to them. They could get redress their grievances by the Commission, saving a lot of expense and trouble. Further, the two world wars and the resulting the Great Depression, led to multiplication of administrative agencies like the ICC. In the course of time, these agencies became very powerful. The bar and bench could not take this development kindly, as they were still under the influence of Dicey's view that administrative law was completely opposed to Anglo-American principles. A special committee on administrative law was appointed in 1933 by the American Bar Association to make certain changes in the functioning of these bodies. This committee recommended for greater judicial control over administrative agencies to check against the excessive power and abusive exercise of power. Even the government was anxious that something must be done to prevent these agencies, styled as headless fourth branch of the government, from being a law unto itself. Not accountable to the president, the ICC came to be regarded as a miniature independent government. President Roosevelt, in 1938, appointed the Attorney General's Committee to investigate the need for procedural reform in the field of administrative law. Based on the recommendations of the committee, the Federal Administrative Procedure Act was enacted in 1946. This was a very big T containing more than 600 sections. It contained several provisions for the judicial control over the actions of the administrative agencies. It has been treated as a new basic and comprehensive regulation of procedures in many administrative agencies. This act was designed to give uniformity to the rule-making and adjudicative proceedings of federal administrative agencies. This act was enacted in response to increasing resentment against the attitude of agencies in matters affecting the rights of individuals. The act brought coherence and judicial character to formerly haphazard procedures. This act provides minimum standard of administrative procedure. According to Schwartz, this enactment gave clear evidence of the desire of the Congress to call a halt to the process of administrative expansion. This act has been recognized as a landmark in the history of administrative law in America. This act provides guidelines for rule-making hearings, adjudicative hearings, intra-agency review, judicial review. It creates rights of counsel at hearings and of public access to administrative hearings. With the enactment of the Social Security Act in 1935, a new trend started in the administrative process in America. The expansion of the administrative powers has not remained confined to the economic regulations. The traditional area of regulation is dwarfed by the growing fields of social welfare and environmental concern. Lord Diplock observes that the American administrative law is increasingly concerned with the affairs of ordinary men and women, their homes, health, and their welfare. There has been another significant development in the American administrative adjudication. An independent administrative hearing officers corps has been established under the Federal Procedure Act, 1946. These officers, initially called examiners, were given hearing powers similar to those of trial judges. They were also authorized to preside over evidentiary hearings and made substantial decisions which, if not appealed, became final. These hearing examiners have been called the administrative law judges under an act of 1978 of the Congress. In 1955, the Second Hoover Commission recommended that the scope of judicial review of actions of administrative agencies should be brought into closer relationship with the scope of judicial review of the decisions of trial courts. The recurring controversies about the powers of the 2-3 administration and the scope of judicial review had healthy effects in paving the way for reasonable judicial control of administrative agencies. The American administrative law has grown exponentially further on the constitutional pillar of due process of law, which insists that no person shall be deprived of life, liberty, or property without due process of law. C. Administrative law in India. Although there was no administrative law in the modern sense in existence in India in ancient times, but there existed the rule of dharma, observed by the king and the administrators or officials of the king, and nobody claimed any exemption from it. Rulers as well as ruled were equally bound to follow dharma. Under the Hindu jurisprudence, there is no concept like British concept that the king can do no wrong. According to Hindu jurisprudence, law is the king of kings. Dharma was a concept wider than rule of law and due process of law. It comprised basic principles of natural justice and fair play. Under the Mauryas and Gupta's empire, several centuries before Christ's, there was a well-organized and centralized administration in India. The art of governance was well known to Hindus, and the duties of the king and other organs of the state were laid down in ancient scriptures and literature with minute details. In ancient India, state assumed character of welfare state. The object of ruling is prajahita, welfare of the people. But there was no machinery to enforce the rule of dharma so far as applied to the king. It was the moral duty of the king to abide by the rule of dharma. During medieval period, the administration was based upon Islamic concept of law. In this period, the administration was centralized and the principles of administration were not well established. British period. With the establishment of the East India Company and the beginning of the British rule in India, the administrative law in its modern sense started taking shape. The object of British administration was to maximize profit, revenue, and for this efficiency in the administration was the chief necessity. The executive administration was invested with such wide and overriding power to make rules as a modern democratic legislature cannot even imagine. At that time, the purpose of administrative law was police state and law and order only. During this period, numerous acts and regulations were also enacted by the British government to regulate public safety, health, morality, transport, and labor relations, but the functions of a welfare state were not discharged by the administration effectively. During this period, various writers draw attention in the field of administrative law. In 1901, S.R. Das published a book containing interesting materials on Indian administrative law. An important attempt was made by Tagore. Law lecture in 1918. Chandra Shekharan published a book in 1938 as Administrative Law in Madras. As in other parts of the globe, the world was brought in India a plethora of administrative agencies exercising control over almost every aspect of the individual's life. The court though had ample powers to set aside an administrative action, yet they paid great respect and attention to their decisions. Till the end of the British rule in India, the government was primarily concerned with its own existence, dominance and discharges only those functions which were essential, e.g., collection of revenues and maintenance of law and order. Industrialization and economic welfare of the Indian people was not the policy of British government. Because of these reasons, although administrative law comes into existence but did not take concrete shape. Post-independence period. After independence, the whole philosophy about the role and function of the state has changed, which resulted in the growth of administrative law in its modern sense. The philosophy of welfare state was made the essence of Indian constitution, and provisions were made to secure to all citizens social, economic and political justice, equality of status and opportunity. To secure these welfare and socialistic aims and objects, the Constitution has provided an equipped and exhaustive functional government and administrative mechanism. All the important aspects of the administrative law, like delegated legislation, judicial review of decisions by tribunals, government liability, has been incorporated in our Constitution. The Constitution also provides for some administrative agencies to regulate a particular filed an issue, e.g., Interstate Council, Finance Commission, Interstate Water Dispute Authority, Public Service Commission, Election Commission, etc. In India, the judiciary has also played a very constructive and significant role in the development of administrative law. The Supreme Court has gradually built up a body of rules to regulate administrative behavior to prevent its degeneration into arbitrariness. The underlying objective of these rules has been to ensure administrative fair play. Prof. M.P. Jan has very rightly observed that the present-day body of Indian administrative law is primarily the creature of the courts. This is because the Indian legislature has been singularly oblivious of the needs to develop a viable system of administrative law and has been remiss in tackling constructively the problems existing in this branch of public law and in suitably adapting the legal norms to contemporary societal needs. In other common law countries, legislatures have over time enacted statutes to strengthen the control mechanism over bureaucratic process in order to reconcile the conflict between individual rights and administrative needs, but not so in India. Here administrative law is primarily what has been evolved by the courts. 2.5. Today in India, the administrative process has grown so much that it will not be out of place to say that today we are not governed but administered. In this context, the Law Commission of India rightly observed, the rule of law and judicial review acquire greater significance in a welfare state. The vast amount of legislation which has been enacted during the last 3 years by the Union and the states, a great deal of which impinges in a variety of ways on our lives and occupations. Much of it also confers large powers on the executive. The greater, therefore, is the need for ceaseless enforcement of the rule of law, so the executive may not, in a belief in its monopoly of wisdom and its zeal for administrative efficiency, overstep the bounds of its power and spread its tentacles into the domains where the citizen should be free to enjoy the liberty guaranteed to him by the Constitution. Observations of the Law Commission are more relevant today when India has adopted the policy of liberalization, privatization and globalization in which administrative law has acquired international dimensions. Though state is now withdrawing from business, yet its functions as a facilitator, enabler and regulator are bound to increase. Growth of new centers of economic power which often exercise power in total disregard of the fundamental rights of people, especially of the disadvantaged sections of society, will put emphasis on the development of new norms of rule of law and judicial review for reconciling economic growth with social justice. 170.